Hello. Today I'd like to talk to you about contracts. Here is a famous contract that I'm showing on the screen. It doesn't look very good. It looks sort of informal. It was written on the back of a receipt at Ye Old Virginia Restaurant a few years ago by a couple of guys who were hanging out and drinking heavily one night, and the thing that it said on the back was, "We hereby agree to sell to W.O. Lucy the Ferguson farm, complete for $50,000, title satisfactory to the buyer." And it was signed by the seller and his wife, and the buyer agreed to this contract. Well, next day, seller sober, buyer sober. Buyer says, "All right, I'm ready to buy." The seller says, "No, I was just joking around. I was just drunk." The buyer said, "I don't think so." This case went to court, became a famous case, Lucy versus Zemer. And the court had to decide whether there was actually a real offer and acceptance of this contract, or was it just a joke or something done by a couple of drunk people and that shouldn't be upheld in court. And the court decided that, yes, this was a contract, and yes, basically, Mr. Lucy had the right to buy the property. And so the court forced the Zemers to sell the property to Mr. Lucy. This is just one example of a famous contract. All right, so let's talk a little bit about what's going to happen, or what the objectives are of this area of study, or this chapter. We're going to talk about classifications of contracts and some of the terminology used to describe contracts. We're also going to describe the requirements needed to create an enforceable contract. And you will know when a contract must be in writing, and identify instances in which mutual agreement cannot exist. Contracts are just promises that are enforceable with predictable consequences for performance failures. It enables buyers and sellers to account for future risk or have confidence in exchanging valuables. A contract does not always need to be a formal written document, although, of course, businesses generally do want things to be as formal and written as they can. That reduces the likelihood of disputes later. Contract law enables private agreements to be legally enforceable, and it provides flexibility and precision in business dealings. Now, there's a couple of sources of contract law. Some come out of legislation, like the Uniform Commercial Code, which governs the sale of goods. And the Uniform Commercial Code is sort of a recommended set of statutes. And it's been adopted in all 50 states in some form or fashion. Some things get a little bit amended, but this is kind of a recommended uniform way to do things for the contracts of goods, which does make it simpler for lawyers when they're dealing with goods that may be in several states, because the state laws are often very similar because they're based on this Uniform Commercial Code, or this recommended law that was drafted by some attorneys and other advisors as the recommended way to go. Also, there's common law. There are judges' decisions that also affect contracts, and those are mostly contracts for other things other than goods. So, for example, common law generally governs contracts for things like real estate, although still there are some statutes that deal with real estate sales. Classification of contracts. Well, one type of contract classification is bilateral versus unilateral. Bilateral contract is when there's a promise or an exchange of promises, or a promise given exchange for, let me start over. Bilateral contract is a promise exchange for another promise. So I may promise to sell you my computer for $500, and if you promise to buy my computer for $500, we have a bilateral contract. Unilateral contract, on the other hand, is a promise exchanged for performance. The best example I can think of a unilateral contract is when I put signs in the hallway that say, "Reward $500 if you find my lost laptop and bring it back to me. You haven't promised to do anything, so there's no exchange of promises. I'm the only one who's made a promise that I'll pay $500 if you find my laptop and bring it to me. So there's no contract in a unilateral contract or reward type situation until you perform. Once you perform, we've got a contract and I have to pay you the $500. Express and implied in fact contract is another example. So express is where all the terms are set forth and discussed. Implied is when things are not spelled out. They're not specified, but they can be implied from the situation. For example, if you went to visit a doctor and they didn't have you sign anything, but the doctor treated you, there would be an implied in fact contract there, and it would be assumed from the facts that you would be required to pay the doctor. There's also implied in law or quasi-contracts. That's a legal creation. This makes a contract even though none was really intended. And this is there to try to keep someone from being unjustly enriched at the expense of another. So, for example, if you owe the bank $10,000, but you accidentally pay them $10,100, there is sort of a possibility there of unjust enrichment of the bank by $100, and so the bank is required to send it back. Another good example would be if you walk out your door and you look around and you see there's somebody's getting ready to paint your house. A professional house painter is there, setting up his ladder, getting ready to paint your house. And you realize that the painter's at the wrong house. But you're excited to get your house painted, so you say nothing and let the painter do it. Even though you had no contract that was expressed with that painter, you've been unjustly enriched by the painter, and so there's an implied in law contract which would say you have to pay him for his services in a reasonable amount. So, express contracts arise from interactions in which the parties discuss the promised terms. Implied in fact arise from the conduct of the parties rather than from words, and implied in law is basically happening when there is no contract, but it's a judicial remedy to prevent one party from receiving unjust enrichment. Now, there's some enforcement terminology as well. Some contracts are enforceable in court or can be upheld in court. Unenforceable contracts means that somebody has a good reason not to perform. So, generally a valid contract is going to be enforceable. But a void contract will be unenforceable. An avoidable contract is kind of this middle ground where a party has a chance to void the contract. It may be valid at the beginning, but it is voidable by a party. So, what's an example of a valid contract? When I signed a contract to sell my home to another party, we had all of the requirements for an enforceable contract, which we'll discuss later, and everybody had legal capacity. We were over 18. We were of sound mind. There was offer, acceptance, consideration, legality, so it was a valid contract, and it was enforceable in a court of law. On the other hand, what would be a void contract? Well, if I signed a contract that was illegal, example might be if I signed a contract that said I would kill your spouse, and then you didn't pay me. Well, I couldn't go to court and enforce that. It would be unenforceable because that would be an illegal contract that's void. Similarly, a contract dealing with gambling debts, if gambling's illegal in your state and you go ahead and gamble anyway, any contract to be paid in that situation would be void. Also, if you go to court and represent somebody and you pretend that you're an attorney and then your client refuses to pay you later, the court would call that a void contract for services because it was illegal. It's illegal to practice law if you're not an attorney, so the court would say, since you don't have a license, you don't get paid. That contract's void and unenforceable. Now, this voidable thing is in the middle. Voidable means that one party to the contract has the choice to either continue on with the contract as if nothing's wrong, or they have the choice to withdraw from it. The most classic example is a contract entered into by someone who's under the age of 18 years old. So, for example, if you sell a car to a 16-year-old and you give them the keys and the car title and they give you money, they have up until a point shortly after they turn 18 to back out of the contract and give you your keys and your title back and get their money back. That's voidable. However, they may decide to keep the car forever. And if they don't back out or basically get out of the contract by the time they're a little bit over 18, within a reasonable time after their 18th birthday, then you should be fine. Now, there is one exception, and that is for necessities. If a minor buys food or maybe medical care or some kind of thing that is a necessary item for their life, then that contract may not be voidable even though the person's under 18. Now, you do need to remember these requirements for an enforceable contract. There's offer, acceptance, consideration, capacity, legality. In addition, people can, even if all of these exist, people can try to get out of a contract if it's in proper form. Some contracts must be in writing. Not all contracts, but some must be. For example, contracts for the sale of goods over $500 may be required to be in writing in some states. In addition, contracts for the sale or conveyance of real estate have to be in writing by virtue of the statute of frauds. Some contracts can be verbal. In addition, a contract. A party may be able to get out of a contract, and it may not be enforceable in court if there's no true meeting of the minds due to something like fraud or mistake. All right, so back to the offer. It contains a specific promise and a specific demand. One must be able to reasonably conclude from the objective evidence that one party intended or meant to make an offer, and that offer must be definite as to its terms so that the other party knows what he or she is agreeing to. For example, an offer to purchase a house at a reasonable price cannot be the basis of a contract because that would be indefinite. The person making the offer is the offeror, and the person receiving the offer is the offeree. All right, so do look back now at that Lucy versus Zimmer case for a second. This question was, is this an offer? And the court said we have to look objectively as, does it look like an offer and is it definite? And the price is there and which farm it is and a little information about the title, and the court felt that was enough to look like a real offer. The court was not really willing to go and try to read Mr. Zimmer's mind, and Mr. Zimmer was not so drunk as to not have any idea what he was signing. And so for that reason, the court said, yes, that's a valid offer under that objectiveness test. They're not going to look at the subjective intent of Mr. Zimmer and try to read his mind. So it was a valid offer. It was a contract. All right, I'm going to stop here, take a break, and I will be back later with some more information about all of these elements of a contract that we've been talking about. Offer, acceptance, consideration, capacity, and legality. Thank you very much.